point clash.
You're not too old for this. How you doing?
How's it going?
Hold on, let me get up there first and I'll talk to you. United States citizen, sir? Yes?
I'm going to opt out.
Well, the thing is, before we can proceed with immigration inspection, if you are, that's fine. I don't really care if you're German or whatever, but are you legally in the United States?
I'm not answering questions.
Okay, then we have to go ahead and take you in. I know you're recording. We'll take you in, identify you, and then you can proceed.
So you're detaining me?
Yes, sir.
That under what probable cause?
On the probable cause, that 18 U.S.C. 111.
What does that say?
Okay, first of all, let me proceed here real quick. Do you have anybody else in you?
There's nobody here.
Nobody here?
111.
Okay.
What?
Can you call and text for the truck real quick? The thing is, hold on. Let me go ahead with my information. First of all, the primary age. Is this your truck or is it a company truck?
It's a company truck.
Okay, registered to the same owner?
Yes.
Swift?
Yes.
Out of Arizona. Okay.
Code 18111 is about impeding me or injuring a federal officer. I've not done that.
Well, the thing is, sir, now that you're actually taking me away from my job.
That's because you're choosing to keep me here.
Yes, I am.
That's
you know
your
why?
choice. That's your choice.
You know why?
Yes.
Because I asked you a simple question. You're a United States citizen.
But prior to prior to our encounter,
yes.
there was no probable cause to even stop me. So any further search is invalid.
No, sir, you're incorrect. You know very well this is a immigration inspection.
Yes.
As a trucker, interstate trucker,
yes.
You're aware that at southern borders, California, Arizona, we have checkpoints.
Yes.
Right? And you know that they're going to ask you questions.
You're asking everyone questions.
Yes, every single one. Everybody that you see before you and that camera can see will actually do that.
I'm gonna make 3 statements. Okay, I'm not asking you. I know these are true. Your establishment is here lawfully. Yes.
Yes, it is.
You're asking me these questions here lawfully.
Yes.
Yes. I'm obligated to answer them. No.
This guy has no idea what he's doing. Arguing with a Border Patrol officer like this is a terrible idea. It's definitely not going to end well for him.
Well, no,
I am not.
That's not correct.
Yes, it is.
No, it's not correct.
Any 18 code that you say is subordinate to the U.S.
Are you an immigration inspection, sir?
Excuse me?
Are you an immigration inspector?
No.
No? Then you're a truck driver.
What
were your prior job before this, if I might ask? God, man, I'm getting the
Any code that you follow is subordinate to the U.S. Constitution. Okay, so my Fourth Amendment is unalienable.
What is the Fourth Amendment, if you can tell me?
It regards search and seizure. And
I'm not seizing you, or actually,
you just said you were detaining me.
Yes, I'm detaining. That's not a seizure. Do you know what a seizure means?
You're seizing.
You know what a seizure means?
Like confiscating.
Yes, taking away that you're no longer.
But the search part.
The search part is not a search. I'm just asking you a simple question.
Why am I being detained?
Because we're asking a question.
You don't have probable cause. I don't have to answer that. You understand? I don't have to answer the questions.
You do.
No, I don't.
Then I'm going to ask you 2 questions.
If I'm breaking the law, then arrest me.
Oh, you will be detained. Okay.
Arrest me then if I break the law.
You're being detained.
I'm not getting out of the truck. I don't consent, and I'm not getting out of the truck. Look, man.
Before I fall, I don't want to break your glass.
As long as you don't grab me.
Go ahead, close it. Can you close this one? Open it. I don't want to break your glass. We're not going to open it.
What is that for?
Go ahead, put it down. Put it back.
No.
I need you.
Hey,
I'm
man.
going to break your glass. I don't want to break your glass.
Look, man. I should be able to travel down these roads without being stopped. All right? I need you to get off the window.
No, because you're going to close it. You go.
I
need a camera. I need a camera.
I'm
This guy is refusing to go in and cooperate, so I'm going to need to take him out of the car.
I'd rather you not touch me or be forced to do anything.
Well, you will be extracted from this vehicle, sir, unless I'm satisfied with the immigration inspection. Do you understand? Do you understand, yes or no? We can stop here. We can go up the north. You can actually keep on going north on your way and proceed, or we can go ahead and remove you by force and identify you, sir. Do you understand?
You want my driver's license?
No, I just need a you're American citizen.
Now, let's say that I just answer your question. What does that...
It just means that, yes, you are, and you can go to your immigration inspection. This isn't an inmate...
What if I was lying? What if someone lies?
Sir...
it all just falls apart when you...
Okay, are you lying to me?
So
then my probable cause just...
I'm not answering your question is the thing. I'm not answering your question. I'm going to
ask you...
So you don't have probable cause to begin with.
Yes, I do.
Prior to the encounter.
The conversation was real simple, sir.
No, it wasn't. It
Yes.
should have never happened in the first place.
Okay. If you have not gone through here, then it would be fine. My question to you, we can stop this right now.
So you're
You
saying...
can proceed northbound if you answer my question. Until I'm satisfied with my immigration inspection, then we're fine.
My answer to your question...
Then I'm going to have to extract you.
Is that...
By force.
Under what cause?
Under 18 U.S.C. 111.
What does that say?
You're impeding, sir.
No, I'm not.
You're impeding
No,
my,
I'm not.
my jurisdiction.
Have you
sir.
sustained any injuries?
Not yet.
That's...
I will.
Then I am not violating that code.
Yes.
No, I'm not.
Sir, I'm asking you one last time, sir. We're recording this as well.
That's okay. I've not broken any laws.
Then you're going to be extracted.
I'm going to be
read this to
extracted.
you real quick, sir. I'll read this to you.
What is that?
18 U.S.C. 111, assaulting, resisting, or impeding certain officers or employees, which is me. Forcibly, agents, assaults, resists, opposes, impedes, intimidates, or interferes with any person designed in section 1114 of the title while engaged in or an account of a performance of his official duties. That's where we're at now.
I'm not interfering with that.
Okay,
You're
or
keeping-
intimidations
you're
of any
keeping me
person
here on your own
formerly
accord.
served as a person designated on section 1114 on the account of the performance of the official duties during such person's term of service shall, where the acts in violation of this section constitute only simple assault, be fined under title or imprisoned no more than 1 year. Okay? Oh, you talked to this guy before? What was his status before? Hey, you recognize this guy?
No.
You don't? Okay. It would have made it easier if you didn't. The Immigration Naturalization Act, CFR 8 and 22, federal policies and landmarks, U.S. Supreme Court decisions grant Border Patrol agents the authority to conduct checkpoint operations. Motorists should not be permitted to proceed until agents are satisfied with the inspection procedures. Okay? This is a U.S. Patrol checkpoint, and I'm intending to conduct an immigration inspection under Section 287A3 of the Immigration Nationalization Act, INA.
I have not broken any laws.
The Supreme Court has ruled under U.S. versus Martinez-Cortez 1976 that the U.S. Border Patrol has authority to set up permanent or fixed checkpoints on public highways leading to or away from the Mexican border, and that these checkpoints are not violation of the Fourth Amendment.
Yes.
You are being ordered to move out your vehicle to secondary inspection, which you already are, to allow us to complete the immigration inspection. That's what I was trying to get you to do. If you do not move your vehicle, which you did already, you can be arrested under 18 U.S.C. 111. However, if the motorist refuses to exit the vehicle, agents will use the amount of force necessary to effect the arrest and enforce compliance to the lawful order, including removing the driver from the vehicle. The vehicle should be searched, incident to arrest, and moved to secondary inspection to allow resumptions.
And all of this is based on probable cause, right?
This is the United States Border Patrol checkpoint, and I'm attempting to conduct an immigration inspection on Section 287A3 of the Immigration Nationalization Act. Okay, so I'm asking you right now.
I want you to know that as a person driving down a U.S. highway,
I can't hear you guys pick up the trucks.
I want you to know that I'm very frightened right now.
Why?
Because...
would you talk to me only?
Yeah, you're... This big, gigantic group of people is...
Do you know why they're here, sir?
Because everybody has a mortgage to pay.
Negative. You're driving because you have a mortgage to pay.
Yeah.
We have a job to do. And under Section 287,
and
this is a checkpoint. I'm asking you, sir, for your cooperation. This is the last time, sir.
I've cooperated as much as I need to.
I'm not satisfied with my immigration inspection. I'm a supervisor. I'm in charge of the checkpoint.
You're not supervised.
I'm asking you this last time. Cooperate or you be extracted out of the vehicle.
I am cooperating.
All right. So I'm asking you.
I am cooperating.
Okay. Are you going to step out of the vehicle and talk to me, or are you going to have to extract you out of this vehicle? This is all being recorded from both phones. Your phone and my phone.
I don't want to be extracted from my vehicle.
Okay. Are you going to go ahead? Are you going to go ahead and cooperate, sir?
You want me to go inside?
No. I need you to talk to me. Are you a United States citizen? Simple yes or no.
That makes no difference to me traveling down a road.
Okay. I need you to step out of the vehicle, sir.
I will not. I don't. Really?
Sir, I'm telling you right now.
Hey, man.
Fingers in there, I swear to God.
No, I'm not gonna hurt
Okay.
anyone. I don't want to hurt anyone. Why are
Okay.
y'all doing this?
Because
Let
I'm
me
asking
go.
you, sir.
I just want to go.
No,
I just
you are
want
going
to
after
go.
I'm complete with my inspection.
So
Go
you're-
ahead, open the door, sir.
I will not.
Open the door or I'll break this glass.
Dude,
Are you still recording this? Open this door or I'll break this glass, sir.
I have not done anything wrong.
I'm asking you. You're failing to go ahead and
What
cooperate,
have I done
sir.
wrong? What
You failed to
laws have I
cooperate
broken?
and actually the
I
immigration
haven't-
inspection, sir.
I just want to go down the road
You
freely.
will after I'm complete with my immigration inspection.
I
Do
just
you
want-
understand?
I don't like these intimidations.
It's
I
not
haven't done-
intimidation, it's the
yes,
law.
it is. It's not the
I'll
law.
count you 3 and I will break this glass.
Don't break the glass, man.
1,
Shit.
open the door. 2,
I haven't done anything wrong.
open the door. Open the door.
I haven't done anything
Open
wrong.
the door.
I'm not breaking any laws.
Open the door.
Man,
I don't
Fuck,
want to
man.
break the glass.
don't
Open
do
the
it,
door.
man. It's not even my truck.
I know, well then open the door.
Man, this is absurd. I can't
is.
believe you would do this.
I will. Open the door. It's not the first one I've done.
I'm a bet, but I have not broken any laws.
Then open the door, sir.
I've not broken any laws, man.
How many times do I have to repeat myself? Open the door.
I don't want to get out of the truck. I haven't broken any laws.
You
I haven't
broke
done
in this
anything
law,
wrong.
sir. Section
No, I
27.
haven't. No, I haven't.
Go ahead.
I haven't broken any
Open the
laws.
door.
I've complied as much as I need to.
Stand back.
No,
Stand back.
Safe like repair, safe like replace.
Judge Simpson destroys sovereign citizen in court. You come in when I tell you to. Zoom is optional. In this heated courtroom showdown, Judge Simpson takes control as a defiant sovereign citizen attempts to challenge the legal system. Watch as the judge shuts down his arguments with authority, reminding him who's in charge. You come in when I tell you to. With Zoom participation being optional, this sovereign citizen's tactics don't stand a chance. Don't miss this epic takedown. Like, comment, and subscribe for more intense courtroom moments and sovereign citizen fails.
Court calls case People versus Tariq Day.
Nimish Ganatra, Senior Assistant Prosecuting Attorney for the People.
Hello, Tariq Samar Tariq Day here.
Already, Judge Torsho Fieser, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
Oh boy, here we go.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now,
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no
You
way I
have-
can.
in a vehicle with a hat on, no mask. Oh,
I am inside my vehicle right now.
what'd you say?
I said yes because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you
So
go
there's
to
no-
the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're gonna do. Then I'm gonna say, okay, you got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're gonna represent yourself.
I can't make that. Is there a later date?
Oh,
3:30?
yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then we can.
Okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
The "oh, I have COVID" excuse didn't work with Judge Simpson since this sovereign citizen wants to represent himself. The judge made it clear he must appear by 3 p.m. that day or risk a bench warrant being issued. Do you think this sovereign citizen will make it by 3 p.m. even though he's trying to request an extension until later or another day? Let's see if he truly believes he's in control here or if deep down he knows the judge actually has jurisdiction over him.
Why don't we do this? Give me about 3 minutes. I'm going to take a recess, then I'm going to come back because everything's going downhill and it's those two guys' fault. What's your name?
Tariq Samar Tariq Ade, the executive of the Tariq Samar Tariq Ade Living Trust. Owner Tariq Ade, Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter.
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding 3rd degree.
3rd degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact.
Motions need to be written, not just spoken, and you don't get a dismissal just because you want one. Let's see what the judge thinks of this sovereign citizen's nonsense.
Of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest. Arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
That They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied.
Here we go, folks. His motion has been denied, so we're about to hop on the sovereign citizen carousel. Let's see how this one turns out for him.
Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right, so how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You
a
stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept
No.
as to what they mean.
demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not,
No need to.
they are not,
I'm not here.
they are virtually the
Right.
same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You
to-
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes,
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. So are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant. How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him.
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it Sheriff?
I do, Your
Okay.
Honor.
Okay, gotcha. All right, you'll make sure that that is sent to him. You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter in regards to the name as well as the vessel that was used is again under it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, and Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that.
All right, so here's what we'll do because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step. And I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person.
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple councils extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
Just for the record, I'll put it on the record that I object, but under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Conclusion: this sovereign citizen believed he could have things his way, but Judge Simpson made it clear who's really in charge. When you try to play lawyer while attending Sovereign Citizen University, you're bound to get burned by the real court system that he refuses to respect. Don't forget to subscribe and share. I'll see you in the next video. Thanks for watching. Judge Oakley versus Sovereign Citizen, Moisa Courtroom Masterclass, taking control like a boss. Watch as Judge Oakley skillfully handles a sovereign citizen's antics in this intense courtroom exchange. With unwavering composure and authority, Judge Oakley sets the tone and takes control of the situation, showcasing exactly how to maintain order and respect in the courtroom. A must-see moment for anyone interested in law, courtroom dynamics, and the art of commanding authority.
All right, appearances for the People versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771. No, it's not. You have work. So yeah, you're on trial here. Are you representing at the desk representing yourself? The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry. Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and no, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I have recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today.
You have a jurisdictional argument you want to make?
Well, I served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
Judge Oakley is about to teach the sovereign citizen a lesson as he attempts to use a flawed jurisdiction argument to wiggle out of his charges, but the judge isn't tolerating any of his foolishness in the courtroom.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
and
it?
It's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
sworn complaint signed, all,
You want to see it?
affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I'm first saying,
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
Did I object? What am I supposed to say?
I want to know if you understand, you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Nice.
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the
I object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing, Mr.
It's
Michaud.
still, on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not gonna let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today.
The court has been very understanding when it comes to family issues, but Judge Oakley isn't going to let this sovereign citizen talk over him or play games. The problem is the sovereign citizen refuses to understand the law and cooperate to resolve the case. If he doesn't get it together soon, he's looking at a more serious contempt of court charge.
That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? Because if it's a hearing. or
You
a conference,
didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As
with
far as
counsel.
I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First
address my
notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal
the
what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There is no
did-
bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me
Well,
and figure.
okay,
Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you
Can
got in
you-
front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great.
you haven't-
Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize
what-
that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse. For you and nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It does, it should mean something
Can you
because,
prove it? Please prove
can
it.
I prove
then.
what?
Prove that I am not that I am the artificial person. Here
I
it
can
is.
prove you're Frank
I have
Michaud.
full faith and credit.
I can
I
prove.
have, okay, so.
Hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I asked
You
for
proved
you
it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay.
you're still threatening me and you're using it under color of law.
Okay, listen.
And plus
Listen
you
to
have,
me. Mr.
you
Michaud,
have, you have.
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So.
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
He gets held in contempt of court and ends up in jail simply because, like most sovereign citizens, he doesn't know when to stop talking and follow the rules. In court, it's not about your personal beliefs. This is the legal system, and you're not getting it your way like you're at Burger King.
For what?
for contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. No.
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him.
It don't play here.
The court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's
case.
the worst part about all these cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good
Ron White,
argument.
right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
You can't fix stupid.
The judge gives the sovereign citizen 30 days, cutting through the nonsense. Judge Oakley doesn't entertain the soft approach sovereign citizens try to use, refusing to let them take control of the courtroom. He's firm, and he runs things by the book, not letting them derail the proceedings. Sovereign citizen tries to dodge repo by claiming judge is his trustee. Legal fail. In this bizarre courtroom moment, a sovereign citizen attempts to avoid a vehicle repossession by claiming the judge is his trustee. Watch how the judge responds to this confusing argument and how sovereign citizen tactics fail once again. This video shows the challenges courts face when dealing with these unconventional legal claims. Don't miss this entertaining and educational courtroom showdown.
Ms. Walsh, are you going to be arguing this?
That's correct. Good afternoon, Your Honor.
Good afternoon. I think I see a Jeffrey Lawrence.
Jeffrey-Lawrence, Cowgill, beneficiary.
Case involves a defaulted vehicle loan for a recreational travel trailer. Defendants executed and entered into a retail installment contract with the dealer. The last payment made on the loan account was on or about December 28th of 2021. The balance owing to plaintiff is the principal sum of $35,928.21 plus late fees in the amount of $53.88 plus accrued interest in the amount of $1,325.37. While they have submitted many pages of inadmissible hearsay, including excerpts from several books and alleged excerpts of statutes and constitutional provisions and postal tracking information and other materials, documents that appear to have been drafted by defendants themselves that have names like conditional acceptance or bill of exchange or a declaration of the Naturalization Act of July 1779 for Jeffrey L. Cowgill status correction to the land and soil jurisdiction, not Sea Admiralty. They elaborate on the allegations that the credit union rejected payment that
Basically, the sovereign citizen is attempting to justify why they don't owe the credit union any money, relying on more of their typical sovereign citizen rhetoric and misguided legal theories.
note, but those forms of alleged payment are not legal tender, and the credit union was not obligated to accept them as forms of payment. Defendants also argue that they sent a bond coupon in the form of a promissory note to the credit union as an attempted tender of payment under the contract. However, defendants have not submitted any admissible evidence to support that proposition, and even if they had, that is not a valid form of payment. So the plaintiff asks that the court enter the revised proposed order granting summary judgment to plaintiff.
Mr. Cowgill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey-Lawrence, Cowgill, with Teresa-Ann Cowgill, the beneficiaries, make a special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher. This is a Sesticate Trust action, which you are now a real party in interest to. I'm the living, breathing man on the land and soil. That entity, all caps, Jeffrey Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all-cash entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states. The defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance. The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange? Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted affidavits that they are not qualified to submit, how can their words be trusted? They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time. Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is the signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain? Esquire Bertolino states that the instructions on the 1099A state tangible property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. Payments in fiat currency were being made until we discovered the truth and the plaintiff's agents violated laws and codes. All they had to do is return the bills of exchange with dishonor and or validate the debt or answer the conditional acceptance. Instead, they ignored us. That's why we're here. The Federal Reserve publications, like Hearing the Truth from the Horse's Mouth, state exactly how banks operate. How is that not fact? The Federal Reserve dictates what the banks can and cannot do. I'd say their publications are not only admissible, but damning to the plaintiff's complaint. As the plaintiff, they have to prove their complaint, and not only are there holes in their contract theory because of the signature, but it begs the question, why are they dismissing the UCC, which all banks and courts are bound to? And why didn't they rebut the UCC one? And as for the Leach Act, I submitted the copy to the court from the plaintiffs behind a sealed financial record. There's no explanation for these agents or their office to be passing around sensitive information that the agents do not need. So they did violate the act. What is their confidential material protocol? Who has seen the documents and where is it stored? How was it sent to the plaintiff's agents? By mail, fax, email? So how can you tell me it was secured when they didn't take the precaution when they send it to me in regular mail, not certified? The plaintiff never asked if they could share our personal information of that magnitude. This alone sets forth facts to either dismiss or send this complaint to trial, so the plaintiff's agents can be questioned. Put the qualified bankers on stand so we can find the truth. The plaintiff's esquires are not qualified to speak on the plaintiff's behalf. Mr. Howard is not a banker, so neither is he. I sent, and if you use it without prejudice, like I have, a 1099A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that, I'm done.
Response?
Thank you, Your Honor. The retail installment contract expressly provides that that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations no demonstration of fraud by the credit union or by anyone. There is no defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is, those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and there seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. I guess my answer to that is those probably would not be something you could walk into center with, because it wouldn't be considered regular money for purposes of buying things in a retail situation. They may work in a UCC type thing or something. That this is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner. And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back and then they sell the trailer to somebody else. And they apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm trying to point out it's.
And so my copy of the contract not having a signature from the dealership doesn't matter.
It really doesn't.
And you being the trustee in this case doesn't matter.
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one. As the beneficiary, because I'm not to do that.
Okay, I'm not able to accept that as a Superior Court judge.
So what about them just putting out our social security numbers without our say so? Like, they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. And I read through all the stuff you filed, because it's what I do when I do my job. So,
so can we have those forms of payment back?
Can
you order them to return those to us?
Well, I think it's it's appropriate. If there's some value in those should be returned to
There's a lot of value in them if they still have them. And if they don't have them, then
what happens if they don't return them?
The sovereign citizen stopped making payments on the trailer and attempted to use sovereign citizen arguments and a misinterpretation of the UCC to justify keeping it. However, the judge ultimately ruled in favor of the credit union, ordering the return of the trailer. As expected, the sovereign citizen didn't get his way and claimed he didn't have a truck to return the trailer, asking the credit union to come pick it up instead. Texas sovereign citizen caught driving without license in Kansas, judge shuts him down. Watch as the Texas sovereign citizen faces the consequences after being pulled over in Kansas for driving without a license. Despite his attempts to argue against the legal system, the judge quickly puts him in his place with a firm, no-nonsense approach. This courtroom exchange is a powerful reminder that no one is above the law. Witness the tension and legal expertise on full display.
The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Kervin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction.
Here comes the jurisdiction argument that never actually works. But let's see him try to wiggle out of it. He has been charged with driving without a valid license and currently seems to be sitting in some type of vehicle.
The people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that it gives the court two ways? Sixth Amendment actually gives the court two ways to do it. They can do it through like either like common law or is it colorable maritime admiralty law? Which one am I want to be tried under? With jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation this defendant, you know, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily. And our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well, that's
Therefore,
because I'm just asking questions right now.
if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Ms. Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion but not by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that, because when you say that I consented, is there like a form, was that like,